Good afternoon, ladies and gentlemen. Thank you very much for your support thus far. I am Sukhdev Kaur from Law Chambers of Sukhdev. I am an advocate and solicitor of the High Court of Malaysia, Kuala Lumpur. And this is the community series, episode 2, where I will be discussing another question that is put forward by our guests in respect of will and letters of administration. Now, this community series is intended to give general advice to the community so that they can benefit from the advice and make wise decisions regarding making a will. Okay, so today with me, I have Jasmine Jacob, or more famously known as Jassy, and she's going to, in the first segment, tell you what 2020 and surviving in the year of the pandemic, this COVID-19 era, okay, has been to her to date. All right, over to you, Jasmine.
Yeah, hi, thank you, Sukhdev. So yeah, as what Sukhdev has introduced me, I'm Jasmine, aka Jassy. So like what we were discussing earlier, because of this pandemic, I'm actually a real estate agent. I have been a real estate agent since 2015. I still am a registered real estate negotiator. But due to the pandemic, since February, I have not been having any closings. So it was quite financially difficult for us. So during the first lockdown, I started doing, beauty and skincare business. So I was like selling skincare products. I was doing makeup for people. But then again, because of the pandemic, many events like weddings and other events have been cancelled along the road. So, makeup services was not really that, not really that growing at that time because of the, lockdown. So then the time when I actually hit rock bottom was when I only had 7 ringgit in my account, and I had to buy Pampers and milk for my son. And that was when someone gave me the idea of cooking and giving out daily catering. So it's like I will cook every day and I will cater to different people every day. So that was what we planned, and I didn't really have much time to think about it. It just happened in a day. Literally, I had to make the decision in a day, and the next day I started the business. So that was what I did, and somehow it has been an overwhelming feedback, and there have been orders coming in non-stop. So this was supposed to be something that I do just during the lockdown, but because of the feedback I have been receiving and the orders that have been coming in, so I decided to do this full time, and that was why I went for my KKM certification. I went for my typhoid jab, and probably along the road later on, maybe next year when the pandemic is lesser, probably I might take a food truck and start doing the business full time. So that's how I've been surviving. I've been able to at least provide food on the table for the family by this way. So yeah, that's how I've been surviving this pandemic throughout 2020.
That's a very good effort put in, Jassy. Tell me, what is your bestseller food?
Right now, we do have Western and Asian, but my bestseller is my nasi lemak.
Nasi lemak sambal udang for sure. Not just nasi lemak. Yes, I have tried, and her food is really good, especially the sambal udang. It's to die for. I will repeat that order, definitely. Okay? All right. So coming on to the second segment, this is where now Jassy gets to ask me a question regarding will and letter of administration, and I will endeavor to answer her question. Okay, so Jassy, what's your question, please?
Okay, my question is this. If, let's say, there is a single parent, okay, and this single parent has a child, and now in the will, this parent states that he or she doesn't want a certain party to be able to have custody over the child when the parent is gone. So that means literally it states that the parent doesn't want this party to adopt the child when the parent is demised. So if the parents were to write that in a will that be able to be taken effect once the parent is no longer around?
Okay, thank you very much. So basically, her question is this: a single parent. A single parent can only mean to be a divorced parent. Okay, because like a widow or widower is also a single parent, but we will come to the situations later. Now, when a single parent makes a will, and yes, you can include a person who you would want to be the guardian of your child or children. You can do that, okay? You can even leave instructions for this guardian on the manner of how you want your child to be raised, the wealth to be used to fund for the health, welfare, uh, for the education of the child in any way that you wish. And you can also state there that the excess wealth to be given to the child upon whatever age, all right, you name it, you say it, it's done. All right. So yes, that can be done. Now, because the courts will look into the welfare of the child, this is to say that even if you have named someone as the guardian, it does not mean that the surviving parent cannot challenge to take over the custody of the child, or to be to co-guardian, to work together with the guardian. It all can, because the paramount interest is the welfare of the child. Okay, so it has to be a round effect. Okay, now what happens if the situation where the parent was a widow or a widower? Then again, you can the guardian who is named in the will make the necessary application to take over and be the legal guardian of the child. Again, the family members may dispute that. All right. So once in court and with all the necessary evidence as to why, who should not be the guardian or who should take over the guardianship will be decided in the best interest of the child. It's the welfare of the child. All right. Now, there is also a situation where if the appointed guardian, for some reason, is not able to carry out the wishes as per the will, perhaps the guardian has passed away himself or herself, or is having health issues, or is mentally challenged, or is facing some difficulties, then it's also wise to name a second person to be the guardian. All right, so that then in such circumstances, the guardian can always come in and make the necessary application to court to take over the guardianship of the child. Now, it is very important to obtain that document from court first, because only then the guardian can step into the shoes of the deceased and carry out whatever needs to be done to ensure that the child's welfare is taken care of. Okay, now once a will is made, you can always revoke that will by making a new will. So say a will is made today and you have named Miss A as the guardian, and in 5 years' time you decide that, you know what, I want to change. I now want to elect Miss D as the guardian. So you can always do that, because it is the very last will before the demise of the testator or the testatrix that will be given effect, and all earlier wills will be revoked. Okay, so you can do that as well. So, and what happens if, for instance, no will was written? then you're actually opening up, for family members or the living ex-spouse to come in and apply for guardianship of the child. So in that circumstance, you will not have control as to who you want and do not want to have guardianship over your child and to take care of the welfare of your child. So in this circumstance, because it is very specific, you're thinking about your child's welfare and not a matter of just distributing the wealth that you have already accumulated. It is very wise to write a will. So ladies and gentlemen, this is another reason why when you can, take the opportunity now and write that will for the welfare of your child if they are still a minor child. It's also wise to write a will even if your child is in his or her university days now, say 19, 20. They are very young. Given the wealth, inheriting the wealth at this age may or may not tend to be abused, because we have all gone through that age. It all depends on individual maturity as to be able to handle wealth, whether at the age of 19 or 20 or 25 or 40, right? So you can always give very specific instructions in your will that this is what you want and this is what will be carried out. Okay, have I answered your question?
Yes, you have.
Okay, thank you very much for the question. Ladies and gentlemen, we have come to the end of our episode 2. The awareness that this episode is emphasizing on is, please make a will to include who you would want to appoint as the guardian of your children if you have children who are still minors. Okay, so with that, thank you very much, Jassy. I wish you very best and Merry Christmas and Happy New Year and a better 2021 for you, for all our audience community. Signing off till next time. Please do not hesitate to contact me and I will try my very best to give you the advice that you wish to seek for. Till then, goodbye.